Hello, Michigan Realtors, and welcome back to another installment of Letter of the Law. Today's segment involves an evolving trend in real estate, the use of showing agents. Particularly during a strong seller's market, when a buyer client finds a home they are interested in, they expect to be able to schedule a showing immediately. Now, in order to meet this expectation, it has become more and more common for established buyer's agents to hire a less established and perhaps less busy salesperson to show a home to their buyers. Now, if the showing agent is someone in the same firm, this can be done easily. The showing agent must be licensed, and they should establish themselves as another agent of the buyer. In a designated agency office, the buyer's designated agency agreement should be amended to add the showing agent as an additional designated agent. But what about using showing agents from other firms? Now, before you do this or permit your agents to do this, you need to consider a number of issues. 1. What is the showing agent's agency status? Is he or she a buyer's agent, a sub-agent of the buyer, a transaction coordinator? Now, the answer cannot be none of the above. The showing agent will need to provide the buyers with an agency disclosure form clearly identifying his or her role. 2. For those of you who believe that transaction coordinator is the best choice, is it really possible for an agent who works exclusively with the buyer and the buyer's agent to serve in that neutral role? Remember that regardless of the initial intent of the parties, it is certainly possible for a licensee to later create an agency relationship through their words and actions. It is not hard to imagine that the buyers in this situation would assume that the showing agent was working for them. 3. Even if it is possible for a showing agent to not have an agency relationship with the buyer, as a matter of law, they do have a common law principal-agent relationship with the buyer's agent. They have been hired by and work at the direction of the buyer's agent here. Now, the legal term principal simply means someone who has permitted or directed another to act or for their benefit and subject to their control. Now, under the law, a principal is generally responsible for the wrongful acts of his or her agent. 4. What is the role or responsibility of a buyer's broker when one of its agents hires a third-party showing agent? Now, an agent can represent another broker with their employing broker's consent, but there is no statutory authorization for one agent to represent another agent in a different firm. Remember, it is the firm that has the agency relationship with the buyer. As a legal matter, many would argue that the showing agent is really working for the firm rather than the individual buyer's agent. 5. What is the role of the showing agent's firm? Now, showing a home is a licensed activity, and that bears repeating. Showing a home is a licensed activity. The broker must supervise all licensed activity performed by its agents. Now, the Occupational Code prohibits an agent from working for another broker without its own broker's consent. 6. How will the showing agent be paid? Remember that the Occupational Code provides that a salesperson can only be compensated by the broker through whom he or she is licensed. A salesperson in one firm cannot pay a salesperson in another firm for any licensed activity. In Michigan, again, showing a home is a licensed activity. Number 7. If the buyer client relies on information provided by the showing agent, are the buyer's agent and firm responsible? Now, buyers are going to ask the showing agent questions, and it is going to be very difficult for the showing agent to defer all questions to the buyer's agent. Again, as a general matter, a principal is liable for actions of their agent. So if there is liability, will the buyer's broker's errors and omission insurance cover the scenario? Similarly, will the showing agent's errors and omissions insurance cover the scenario as well? These are important considerations. Number 8. What if the showing agent falls during the showing, or it is alleged that personal property was taken during a showing? Now, indemnification clauses in listing contracts typically only cover agents in the listing office or the cooperating office, so that will have to be addressed. Number 9. What if the showing agent does not pass on necessary information to the buyer's agent? Suppose, for example, during a showing, the buyers tell the showing agent that their offer should include the deck furniture. Suppose further that the showing agent does not pass this information on to the buyer's agent, who then writes up an offer without mentioning the deck furniture. Who pays for the deck furniture? Number 10. Is the access that the seller agreed to in the listing contract broad enough to cover third-party showing agents? Many current listing agreements only authorize access for agents in the listing office and a cooperating office. It is a violation of both the Occupational Code and the Code of Ethics to provide access to a home other than as authorized by the seller. And lastly, 11. If the buyer finds the home on Realtor.com and views the home with a third-party listing agent, how will this affect the procuring cause analysis? Suppose the buyers decide to cut out the buyer's agent altogether and write their offer through the listing agent. The buyer's agent in this situation may not be viewed as the realtor who first introduced the buyer to the property. If you've made it this far, you can certainly appreciate the number of considerations involved with this evolving trend. And while we hope you have found this discussion informative, please don't hesitate to reach out with further questions at the email included in this video. Good luck out there, and thanks for watching. We will see you next time.